Thanks for staying with us. You're listening to Planet Green Trees. Call numbers 1-347-326-9626. Without further ado, we have our named and titled guest for tonight's show. I'm glad to have you on the show. We've got Mark Brewer. He's a lawyer, political consultant, and member of the Democratic National Committee. He's a former chair of the Michigan Democratic Party and a past chair of the Associate of State Democratic Chairs, and has recently joined a private law firm, Goodman in Acker. I understand he's doing employment law. Welcome to the show, Mark Brewer.
Glad to be with you. Thanks for having me.
Well, you first of all, congratulations on your transition to a private practice, and I wonder if you could tell our listeners how the change has been after being a public servant for so many years.
Well, it's a great transition. I was a election lawyer, campaign finance lawyer before I became party chair. So I'm going back to my first love. In Michigan, for example, I'm Mark Shower's lawyer. He's our candidate for governor. I'm helping Mark Totten, who's our Democratic candidate for Attorney General. I'm working on the minimum wage drive here, so it's been very fulfilling to get back into private practice.
Well, there's a lot of work to be done, obviously, and you mentioned one of the offices that I think is going to be potentially open for the taking, the Attorney General spot, and that brings us to the next real topic. I mean, there's two there, but in terms of the Attorney General position, do you think there's a possibility the Democrats could? Is there a possibility like the Democrats could actually pull off the Attorney General spot? Would there be a split ticket because of Bill Schuette and his some of the controversies?
I think Bill Schuette can be defeated. There's no question about it. He's been very controversial on a wide variety of tactics, failure to protect the environment. He's been a staunch opponent of same-sex marriage. He's just been a real radical and extremist attorney general, and you can see that in the polling data. The last public poll, there's one out just this past week, that showed Mark Totten, even though he's virtually unknown, within just a few points of Bill Schuette. So I think Bill Schuette is very vulnerable and can be beaten in November.
Well, he's a political machine, and the odds are, and I say that not because because the odds are against him. He's an incumbent governor, and it's hard to break that up. But from our position, many in the medical cannabis community have found him to be really intolerable. I mean, I like to refer to him as being obsessed with medical marijuana, and really his position is so inconsistent with his other political philosophies of states' rights and all of the actions and all the claiming and blah, 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 and has not stood up or tried or, anything to really enforce in a positive way, fulfilling his obligations as the leading law enforcement agent of the state to help and assist and make things less ambiguous. But I digress a little. What is the story in Oak Park? And now I understand the signatures were collected, they turned them into the city clerk, and shenanigans began after that.
Right. Signatures were collected to amend the Oak Park City Charter to decriminalize the adult possession and use of less than 1 ounce of marijuana. So this is a case really about access to the ballot. The group, it's called the Safer Oak Park Coalition, circulated those petitions. They got the required number of signatures. The city clerk took a look at the signatures, said, yes, you have enough. And then the city clerk refused to put it on the ballot, despite very clear state law that once the clerk certifies it for the ballot as having enough signatures, it must go on the ballot. So I was retained by the coalition about a week ago now to file a lawsuit in order to try to get them on the ballot, which they have a right to be under Michigan law.
And what was a declaratory action or a?
It's what's called a writ of mandamus, which means that the court, if we're successful tomorrow morning, would direct the clerk to put the proposal on the ballot as state law requires.
I want to believe I saw who the judge was that was drawn. I think he got. I mean, it's one of the more objective on the bench, I would say. What were the pleadings like of the opposition? Have they? What were their responses? Is there a legal basis by which they rely or believe?
Well, we don't think so. They filed their response today. They first said that this issue can't go on a primary election ballot. That's clearly wrong under Michigan election law. Ordinances and amendments like this have gone on primary ballots throughout the state for many, many years, so that's wrong. Their chief argument seems to be that they're not allowed to put this on the ballot until the Attorney General or the Governor approve putting it on the ballot. But again, the statute, the Home Rule City Act here in Michigan, is very clear that the clerk must put this on the ballot even if the Governor or the Attorney General object. And then finally, they're also saying that, well, you don't need to be on the primary ballot, you just be on the general election ballot. Well, the coalition played by the rules. They want it on the primary ballot. The general election is a very different election. If they wanted to be on the general election ballot, they've done this differently. They're entitled by law to be on the primary ballot, and that's what we're going to be asking the judge to order tomorrow.
And do you anticipate a ruling tomorrow? You think after the pleadings have been made? I mean, it's a hearing. Are you presenting witnesses? Is that the stories? Are going to be an evidentiary hearing? How is this going to proceed?
No, there's really not any evidentiary dispute here. It's a legal dispute, so I don't expect there will be any testimony. The judge has all the pleadings. She'll give us an opportunity to argue. She may have some questions tomorrow, and then I expect either a ruling from the bench or a ruling shortly thereafter. When this is an election matter, they have to start printing ballots here in Michigan very soon. So we hope and I expect she'll make a ruling very soon, if not tomorrow.
Would you anticipate, so the opposing party is the city of Oak Park, is that right?
It's actually the clerk of the city of Oak Park, but yes, it's essentially the city.
Is she represented by private counsel, or did the city pay for her attorney?
The city has what's called corporation counsel. It's a private law firm here in Michigan. And so that law firm, a firm named Garen Lukow, is representing the city clerk. Okay. And do you anticipate that they're going to appeal if a favorable ruling should come tomorrow? I don't know, is the honest answer to that. If there is an appeal, I'll have to move very, very quickly because the election deadlines are coming quickly. That's another reason that we hope the judge will issue a prompt decision so that any appeal decision can move forward promptly. But we don't know what the other side will do if we prevail tomorrow.
Where does the premise come from that a local ballot initiative, which is designed for the people living within that specific jurisdiction, the local city or village or township, that's exercising the state right to, or I don't know, is it a charter ordinance or is it a local ordinance law that premises or is it a state law ballot initiative law that is at dispute?
This is governed in part by what's called the Michigan Home Rule City Act, which gives the voters in cities like Oak Park the right to amend their charter and pass ordinances. It does say that any proposed amendments or ordinances have to be sent to the governor and the attorney general. But again, the statute's very clear that neither the governor nor the attorney general have the right to block this going forward. So we believe that the clerk is wrong to say we have to wait to put this on the ballot until we get sign-off or approval from the attorney general and the governor. The statute is very clear that once the clerk determines there's enough signatures, he or she must put it on the ballot. And again, that's what we hope the judge will direct tomorrow.
Historically speaking, has this ever happened in the past? Well, let me ask it this way. Have there been instances where ballot initiatives have, the local cities have passed with approval from the governor or attorney general? Have they chimed in the past, like for some other ballot initiative that may have been, in other years?
Well, they're required by state law to state their views. Sometimes they think the local ordinance or the charter amendment is okay. Other times they object. But again, no matter whether they object or agree, the law is quite clear that the proposed charter amendment, in this case, has to go on the ballot. We have a lot of activity in Michigan. Charters are amended quite frequently. by local voters as are ordinances. In this particular area of marijuana regulation, there have been a number of ordinances over the last several years. Tim Beck is much more an expert on this than I am, where those ordinances or amendments have been presented to the voters, sometimes in primaries, sometimes in general elections, and they've been allowed, as the law states, to vote on them. And what we're asking the judge to do tomorrow is continue that pattern. All this has been done. It's been lawful. It's been proper. This clerk doesn't have any basis to say no.
We have Tim Beck in the queue. We're going to get him on in a second. And I know from the Detroit ballot initiative that was seemingly it's a deja vu to a certain degree. All the legal requirements have been met, and the city council refused to put it on the ballot and took it to the Court of Appeals. And they said, "What part about following the law, do you not understand? I mean, like they did everything they're supposed to. The law is the law. You don't like it, too bad. It's content based. What is the Go ahead. I'm sorry.
Yeah, that's one of our arguments. We cite the Detroit case, which was very hard fought, but the Michigan Court of Appeals, directed the clerk to put it on the ballot. And that's, again, we're relying very heavily on that ruling in front of the judge tomorrow.
Jamie Lowell, who's in the studio, who was the one that called you to get you on the show, and I do appreciate it very much. He wants to ask you a question. Go ahead, Jamie.
Yeah, even if the coalition were to decide to listen to the city of Oak Park and just say, okay, we're going to let it go to the general election, is there any guarantee that they wouldn't be saying something similar when it got closer to the general election, that they still haven't heard back from the Attorney General's office, so it still is not meeting the criteria?
Yeah, that's a real problem. That this kind of conduct, if it's not restrained or changed, could allow other cities to engage in similar kind of stalling tactics, whether at a primary or at a general election. And I know it's very much a concern of my client on a statewide basis that we not allow these stalling tactics to be used. So again, if the judge issues the ruling we hope we'll get tomorrow, that kind of tactic will be put to rest.
Let me ask you this: who do you think's behind this? Do you think it's really the clerk of Oak Park? Is she the, propagandist of reefer madness and is out pouting, like a teetotaler or something like that? I mean, or is there some other political monster behind the scenes that's, that she's the puppet for?
Well, we've not talked or speculated about any motives. We've simply been told by the clerk, and we've taken it at face value, that they don't believe they can put this on the ballot until the Attorney General and the Governor sign off. So we want to keep it very straightforward. We're not casting aspersions on anybody or questioning anybody's motives. What we are saying is that our client and the voters of Oak Park have a right to have this voted on, whatever you may think of the merits. And so we're trying to keep it focused on the law and people's legal rights and not get into a back and forth about motives or anything else. We've seen no evidence that they've got a bad motive here. They are saying, as a legal matter, they can't put this on the ballot. We're taking that at face value, and we'll have that argument in front of the judge tomorrow.
Just a note: the city clerk for Oak Park is T. Edwin Norris. It's a gentleman, so.
Right.
Okay. Let me ask you this, Mark, as a lawyer, as a someone that's not only represented people, taken an oath to the Michigan United States Constitution, you've served the populace, you've been voted, for, and it's of a democratic, political system. What do you make of this? I mean, we've got these rules, we've got these laws where, the interaction between government and citizens, there are rules of how to play, and you have a clerk, the government, resisting the law, the way that it's to be applied. I mean, what do you make of this at that level? Just looking, from 10,000 feet.
Well, that is one of the major reasons I took the case. I mean, I've spent my entire career as a lawyer, and then when I was party chair, fighting for access to the ballot. I don't know if you know this about me, but I have been and continue to be a lawyer for the ACLU here in Michigan. I've done a lot of work about access to the ballot. I think that's critical, that everybody, no matter what they believe, no matter what their background, no matter what their cause, have equal access to the ballot in this country. And so when a group like the Safer Oak Park Coalition came to me and said we denied access to the ballot. I think that's a very important principle to fight for, and really it's a fight on behalf of everybody in the country, because if the right to the ballot can be denied to the coalition, it can be denied to anybody else. Any group that plays by the rules, like the coalition did, should be entitled to have its proposal on the ballot. That's what this is about.
And as a legislator would say, if you don't like it, go change the law. Just kidding.
That's correct. Yeah, there are ways to change the laws here in Michigan so that, for example, the governor would have to sign off on a proposal, or that things like this would go on a general election ballot. But that is not what the law says right now.
I want to bring Tim Beck in. We've referred to him a bunch of times. He is the mastermind behind this, use of the ballot initiative throughout the state. Tim, can you hear us okay?
Yeah, I can, Michael. Thank you so much, Mark. All I can say, I'm going to defer to Mark Brewer. I mean, I can't really add or detract from anything that this fine man, has stated. I guess, what the major concern here is if this ruling is allowed to stand, it will give persons that don't believe in fair play or playing by the rules an excuse. And I just want to read a thing from their response, Mark, and I know you've read it before. Actually, the level of venom and vehemence from Oak Park is extraordinary. And I'm just reading. In fact, they're saying that we owe them. We have to pay them money, okay, for filing a frivolous lawsuit. And I'm going to quote directly. This lawsuit is little more than an attempt to harass and embarrass the defendant. Okay, that means the city of Oak Park. And defendant should not be placed in a position of having to spend money to defeat a frivolous suit. Okay? They cite a case called Holton versus Ward and, so on and so forth. I mean, it's just, I've seen this before. And, Mark, thank you for declaring me to be a pseudo-expert. I've been through a lot of this. And there is an arrogance within the political class. Democrat, Republican, don't matter. That the concept of a ballot initiative has no basic meaning, and that the normal rules don't apply. And I would suggest that, number one, we're the victims. And, of course, our Mr. Brewer, in our counter, complaint or whatever, said that, no, they're the ones that owe us money. Okay, and that they should pay our attorney's fees for just violating, standard issue law. But here's the problem. I mean, got to be careful here. But again, for someone in, let's say, in the city of Detroit, like Coalition for a Safer Detroit versus Detroit Election Commission, and now Safer Oakland or Oak Park Coalition versus Oak Park. See, the thing of it is, these people, these elected officials, this political class, again, Democrat or Republican, whatever, doesn't matter too much. There are no consequences to them personally because they're being sued. The clerk is being sued in his official capacity. And again, they got all the money in the world compared to a little group like us. And they can just do almost anything they want. There are no consequences. The only consequence, perhaps, is that the voters will, vote the mayor of Oak Park or, and the people that are behind this nonsense, just vote them out of office. But again, they can kind of like do anything they want. And, our concern is that this kind of sophistry can spread if it's not checked come November, because we've got, I do firmly believe, that we got, that the grassroots activists here in the state of Michigan, Port Huron and Saginaw and Mount Pleasant and just East Lansing, all across the board. We've got at least a dozen of them, maybe even more. You see, if we don't check this thing now, what's to stop some rogue elected official or clerk or political class member from saying, hey, F you? Well, I'm sorry, we don't, that's just not our interpretation of the law, so sue me, boy or girl or whatever the hell. And this is the thing that we've got from Oak Park. It's like I say, it's quite shocking, but on another level, I guess it's not. And we've been through this with Detroit, and we've been through this all over. I don't know what they don't understand, but the fact of the matter is they have power and they have personal immunity. And the money doesn't come out of their pocket. I'm sorry if I'm getting way off the topic. I'm sorry. Go on, please.
It makes me want to ask you this next question.
Great stuff, Tim. Yes.
I want to ask you this next question. You're describing, I think, what law school would call the slippery slope theory. And especially it applies in constitutional areas. It's always like a way in which the analysis of a law and the direction, the impact it's going to have on other particular issues. I think judges even think in those terms as well in some instances, like what's it going to mean for their local community. But I asked Mark, and very diplomatically he deferred, because it is a case that is based exclusively on the law, the application of the law that's worked, a law that is available, and a law that's been complied with. And what's the issue? But what do you think's behind this? Do you think it is actually the specific clerk? Do you think he's got a personal issue? Do you think it's Oakland County Sheriff's Department? Do you think it's Oakland County Prosecutor's Office? Do you think it's the commissioners? Do you think it's do you think,
okay, I understand your question, Michael. My personal theory is that it's a kind of, purely local power issue. And I did express that opinion on a listserv. I don't think they want this on the ballot in August, because I think that there's a group of people that have designated an anointed candidate or something like that. They don't want the wrong people to turn out to vote, in August, because it could mess up their candidate, whoever. I'm not going to mention names, that would be inappropriate, but they don't want the kind of turnout in Oak Park, and of course in Hazel Park, because Hazel Park is on the ballot. They don't want people that don't normally vote to show up at the polls, and could mess up their, action, and so-called, I'll say it, kind of like, no, I'm not going to say it, but, mess up their action, That's my theory. That's my personal theory. I can't prove it, but I think that's my sense of what's behind it. That's all. Did I answer the question okay?
Is it a Republican thing or a Democrat thing?
No, it's Democrat. It's straight Democrat. I'm not going to take the bait. I'm not going to. Let me say something. Right now. Hey, hang on, please. Let me just finish. I'll be really brief. I'll be real brief. From what I have heard, that every Democrat Party candidate that's now on the ballot in August is now a full-blown medical. Believes that marijuana should be legalized. So, I guess we're doing the right thing, but on another level, if this is not, on the ballot in August, I don't know if they'll be as firm in their opinion. I'm just, I'm sorry. I'll just shut up.
Well, Oak Park is a staunchly Democratic area, and it's traditionally been. It's on the lower portion of Oakland County, adjacent to 8 Mile, and it typically is a Democratic location, and it is controlled on the council and by the mayor's office by Democrats.
Well, I thought this would be a good way to bring Mark back into discussion. It's such an easy person to blame it all on. It's got to be Bill Schuette, right? He's behind most of the evil.
We think so, anyway.
Mark, I know he's not a favorite of yours. What are your thoughts? Do you think the general public in Michigan knows and understands that he's been so obstinate with the voter initiative of 2008, of an actual election that cast more votes on this issue than any other election ever in the history of Michigan? And
that issue actually has not gotten a lot of publicity. These other issues, the same-sex marriage issue, which was very heavily covered by the media and was struck down by the federal court, and some of these other very controversial cases have gotten a lot more attention than what he's done to try to undermine the 2008 proposal. But it's all of a theme. He doesn't respect the voters' wishes when he disagrees with them. But if he agrees with the voters' wishes, as he did in the affirmative action case that the United States Supreme Court recently upheld the ban on affirmative action here, if he agrees with what the voters did, then, we've got to pay respect and honor the voters' wishes. So he's very selective, very hypocritical in the way he applies it. He's clearly pandering to the extreme right wing of the Republican Party. I think he's got his eyes on being governor in 4 years, and so he makes political calculation after political calculation.
But do you think that this the marijuana issue is really a party limit? I mean, Tim would agree with me that it's one of those issues that really permeates the political aisle and even economic, social issues in terms of the impact it's had, the prohibition of it, the waste of resources, and because I actually think Tim's agreed with me on this too. The Supreme Court, when it heard the first Michigan medical marijuana case, it was People versus Larry King and People versus Kolinek. And there was a unanimous opinion by the Michigan Supreme Court. That's not something that usually, those are not words that are said in the same sentence. All seven of them agreed. And yeah, they believe it, whether they don't care about medical marijuana, but I almost felt that opinion was a reaction to this one individual who was the Attorney General who had crossed over the branch of government into the legislature, was influencing them, that he clearly had some twisted influence on the Court of Appeals, and it was, this Supreme Court, they didn't act for medical marijuana as much as they did to stop and, like a out-of-control power grab, essentially. I don't know, maybe that's a little fantasy, but, his activity at that time was so vocal and so adverse, and it was so propaganda-driven, using state dollars, the clearing the smoke on marijuana was his campaign. What is it? What is it that drives him? Like, do you think is it his own personal beliefs? Because, he's known as Billy Bong in college. Doesn't like to talk about that, or is it, economic, buyers like DuPont and, commercial, big business in terms of the, pharmaceutical and chemical industries. What do you make of it?
I do think that all of his agenda, whether it's affirmative action, same-sex marriage, marijuana laws, all these things are held together by a common theme, and that is his desire to get elected. So he panders to the groups he thinks he needs to pander to raise money and get elected. Actually, when he was a member of Congress about 30-odd years ago, he was much more moderate. He's taken a hard swing to the right, following the Tea Party, among others, and social conservatives in this state. So I really view all of this as part of basically a political calculus. He's doing what he thinks he needs to do to get reelected as Attorney General and then get elected as governor in 4 years.
Yep. We've been very suspicious of Mr. Schuette for a long time, and with good reason.
Yeah. It's politically incorrect, but I think he's nuts. I really think this guy's got some problems, and I'm going to defer to Mark and be realistic here. But here's another factoid. Actually, Schuette's office itself said that Oak Park's action was frivolous. Okay, according to conversations that Andrew Sissel and Deborah Young had with the Attorney General's office. I mean, they really got hardcore with him. And a guy named Mr. Kelly, said that basically that what Oak Park was doing was illegal, more or less, and that the one course of action when you sue Oak Park, because there was no point in Schuette even weighing in because it didn't even matter. His opinion didn't matter. It has to go onto the ballot anyway.
But
I mean, that's literally. I mean, I'm just saying.
In Lansing last year, Attorney General Bill Schuette issued an opinion statement in regards to the election, and that opinion was negative. But it did not.
Yeah, it was. He said that it didn't approve, and you know, you're right. You're absolutely right, Rick. And he listed a whole cornucopia of reasons. But then in the final sentence, he said that you can't keep it, even though he doesn't agree with it, and the governor doesn't agree. It has to go to the ballot anyway.
So just because Oak Park did bad research,
he put that in writing. Schuette put that in writing.
Sure did. Oak Park did bad research, so that we shouldn't have to pay from as a coalition of Save for Oak Park coalition.
He would reference his own opinion were he to be asked.
Right, and that's publicly, that was well publicized. So.
Oh well, I think to some degree, big or small, there is a factor where some people are unsuited for public office because their ego gets so out of control, and they think that they're kind of, you know, God, or they spoke for whoever, and they just say the equivalent, the heck with you, and you question our authority, well, you're going to have to pay us, just like they said in their darn pleadings. I'm going to post this online, by the way. Okay, I'm going to post their response. You know, it's really laughable. It truly is, and as they say, this paragraph that they put in that we owe them money, okay, for embarrassing and harassing them.
Mark, I wanted to... Has Bill Schuette responded at all? I would think with the, you know, controversy surrounding it, it could have, you know, it could have been, like whatever they claim, albeit wrong, could have been effectuated, right? I mean, Bill Schuette could have chimed in and said, "Look, here's my view. I am not giving a view. It doesn't matter. That's the law." Or he could have said, "I disapprove, but who cares?" Or "I approve. It's the law." You know what I mean?
Well,
but
Bill Schuette has chosen not to participate in this, but we have made his views known to the court. We filed with the court today a copy of the letter regarding the Lansing amendment of last year, in which, even though Schuette objected, he acknowledged in the letter that neither he nor the governor can stop it from going on the ballot. So we filed that with the court today, so the court knows that this whole idea that the governor or attorney general have to approve is just nonsense. They won't approve, but that doesn't make any difference. It goes on the ballot anyway.
In that letter you say that you submitted with your pleadings is acknowledged, in it, Schuette acknowledges this fact that we can object all we want, but it doesn't matter, the law is the law?
And it has to go on the ballot, that's right. He said that very clearly in the letter. We quoted the letter in our brief today, and we attached a copy of it so the judge could see it.
Nice. On a side note, I think in the first year, you know, we did this comparison before, of all the attorney generals in the past, they all write between 16 and 25 opinions, you know, per year approximately. Is that right, Rick? I think in his first 2 years, he wrote maybe 6 total, and 5 of them were about medical marijuana, and not one of them was adopted by any court anywhere, or even by his own law enforcement community. Like that, you know, like some of the principles that he came up with and how things are supposed to be interpreted. As far as a lawmaker / you know, principle in terms of interpreting the Michigan, what a disaster! It's such an easy topic for me. Anyways, listen, we only got a couple of seconds left, and I want to let you guys go. You've been very kind with your time, Mark. How critical? This is a critical year. I mean, for the Democratic Party, obviously. You see any like major potential upsets anywhere where there could be a shift either at the federal level or the state level, where things could swing back to some more equal footing?
Yeah, I think there's a wide variety of things going on there. First of all, I don't think Obamacare is going to be the vulnerability the Republicans were hoping. Because I've been urging publicly for months that Democrats run on Obamacare and all of its benefits. Here in Michigan, we talked about how vulnerable Schuette is. I think that Governor Snyder is also very vulnerable. He's raised taxes on folks. He's cut education funding. He's cut taxes for corporations, and our economy is still in lousy shape. Our education system's in lousy shape. Roads are falling apart. So I think our prospects are good, promising, to win both the governorship and the attorney general's race here.
Don't forget he jammed through in the, despite the voters saying otherwise, the Right to Work Act, right?
Yes. It's a laundry list of things that he's done that are completely contrary to what he promised back in 2010.
Yeah, it has been It's lawless government in a way. I don't know. Some of the, for the constitutional lawyers, I think. But listen, fascinating topics. On behalf of the community, I appreciate your work. First, coming on the show and explaining all that to us, but also the obvious hard work you put into the case, your wide knowledge base of this, and your passion to want to succeed. But all people, whether you're in the medical cannabis community, the Republican right wing, the gun toters, or whatever, they all should be applauding this, because this is a lawsuit about the law as it applies to citizens and the right to change the law, and it should not be messed with. And I really appreciate you coming on the show, Mark. And Tim, you're the man, Godfather. Thank you for all your hard work. Seriously.
Yeah, no, my pleasure. I just want to say thank you, Mark, for taking this case, and Michael for being on the show. This is really you guys, Planet Green Cheers are cutting edge. Really, seriously. I mean, it's real. It's very real, and I thank you so much. And we're going to cross our fingers. You'll get a report. I mean, instantly tomorrow as to how this thing comes down.
You should all be thinking about Her Honorable Judge Rayleigh Chabot, sending good vibes her way. I'm sure she's already decided. She's sounds like a good one. So we look forward to hearing back from you guys, and have a great night. Thanks for calling. Right. Look forward to hearing from you. Good luck tomorrow.
Right. Thank you.
Thank you very much. Good night.
Yeah, right.
All right, fascinating. Big lawsuit. I think maybe we'll take a quick break and then come back and do the news. Jamie, is that okay?
Sure.
Quick break.
Quick break, he says.
Okay. Well, you listen to Planet Green Trees. We're going to take a break. The call number is 1-347-326-9626. Got a couple callers in the queue. Stay there, and we're going to be back in a second.